All right, today we're cracking open the official playbook for civil disputes right here in Ontario. We're going to pull back the curtain on the whole process, step by step, using the exact same rulebook that lawyers and judges use every single day. Let's get right into it. You know all those courtroom dramas on TV? The surprise witnesses, the last-minute evidence? Well, the reality is a little less Hollywood and a lot more about a very structured, very deliberate process. So what does that journey actually look like? That's exactly what we're going to map out today.
So here's our game plan. We'll start with the rulebook itself. Then we'll walk through a lawsuit from the very first shot to the finish line. And to wrap it all up, we'll talk about the big question: why this whole structure is so incredibly important.
Okay, first things first. Before we can get into the action, we need to understand the game board. I mean, think about it, right? Without a set of rules for any dispute, it would just be complete chaos. This playbook is designed from the ground up to make sure every single contest is a fair one.
And this, right here, is the heart of it all: the rules of civil procedure. Now, don't let the formal name fool you. This is not some dusty old book of laws nobody understands. It's a practical, hands-on instruction manual. It tells absolutely everyone involved, from the people suing to the lawyers and judges, exactly what to do, when to do it, and how to do it.
And you don't have to take my word for it. This quote says it all. It's right from the very first rule, and it's basically the mission statement for the entire system. It's designed to be just, most expeditious, and least expensive. So fair, fast, and affordable. Keep those three things in mind, because everything we're about to see is designed to hit that target. All right, game on. To make all this feel real, let's use a simple example that we can follow. Imagine there's a small local bakery. They saved up and bought a huge, expensive new oven. But the oven is a lemon. It's faulty, the bakery's losing business, and they finally decide, that's it, we're suing the company that sold it to us.
In every single lawsuit, you've got these two main roles. You've got the plaintiff, that's the one who starts the fight. In our story, that's the bakery. And then you have the defendant, the one on the receiving end. That's the oven supplier. It really is as simple as that.
So how does our bakery officially get the ball rolling? It's a simple two-step process. First, they issue a claim, which just means they file a formal document with the court. Second, they have to serve that claim on the defendant, which is the official act of delivering the lawsuit papers to the oven supplier. And boom, the process has officially begun.
Now that the lawsuit started, it's time for both sides to formally lay out their arguments. This isn't done with shouting in a courtroom. Not yet, anyway. It's all done with carefully written documents.
And these documents have a specific name. They're called pleadings. You have to understand this is the absolute foundation for the entire case. Everything that happens from this moment forward is based on what's written down in these papers. They literally set the boundaries of the entire dispute.
You can think of it like a very formal back-and-forth conversation on paper. Our plaintiff, the bakery, files a statement of claim. It basically says, your oven was faulty and it cost my business a fortune. Then the defendant, the supplier, responds with their statement of defense, which says, no way, the oven was perfect. Your staff just didn't use it right. And right there, the battle lines are officially drawn.
Okay, the lines are drawn. What happens next? Well, now we enter what is often the longest and, frankly, the most critical part of any lawsuit, the discovery phase. If you think of a lawsuit as a poker game, this is the part where everyone has to put their cards on the table, face up.
So what's the point of all this? It's simple. No surprises. The entire goal of discovery is to avoid what lawyers call trial by ambush. The system wants to make sure that both the bakery and the oven supplier have access to all the same relevant information. This makes sure that they're arguing over the same set of facts, which is crucial for a fair outcome. And, as we're about to see, it's hugely important for encouraging people to settle. So how do they get all this info? Well, they have a few key tools in their toolbox. Both sides have to produce an affidavit of documents. That's a sworn list of every single relevant piece of paper, like emails, contracts, you name it. And then there's the big one, examination for discovery. This is where the lawyers get to actually question the other side, orally and under oath. This is how all the facts really come out into the open.
Okay, after all that preparation, everyone gears up and heads to a big, dramatic trial, right? Well, the reality is fascinatingly different. And this is where the statistics tell a really surprising story.
Take a look at this. It's kind of wild. An incredible 96% of civil cases in Ontario are settled before they even get close to a trial. 96%. That means only about 1% of cases actually go all the way to a full trial. The system isn't built for courtroom drama. It's built for resolution. And that's no accident. This is the crucial part. The
The playbook is designed to encourage this. The rules create powerful financial incentives for both the bakery and the supplier to make reasonable offers and find a middle ground. If you reject a good offer and then do worse at a trial, you can get hit with serious financial penalties. The system is actively pushing people toward a resolution.
So we've walked through the whole process from beginning to end. But let's just zoom out for a second and ask the big question. Why is having this super detailed playbook so important for all of us?
It really all comes down to these 4 pillars. First, there's fairness. Everyone plays by the same rules, so our small bakery gets the same procedural rights as the big oven company. Second, predictability. It provides a clear, reliable process so people know how a dispute is going to unfold. Third, efficiency, right? It's trying to get that just, fast, and inexpensive outcome we talked about. And all of that together provides the 4th pillar, access to justice. It's about creating an organized path for anyone to get a fair hearing. So we have this incredibly detailed playbook, designed for fairness and efficiency. It guides every single step of a conflict to make sure there's a structured and predictable outcome. But that leaves us with one final, pretty big question to think about. The rules aim for a perfect process, but can a process, no matter how perfect, ever really deliver perfect justice? The search for that answer? Well, that's really what the heart of our legal world is all about. Thanks for watching.